Judgment in the matters of the Competition and Markets Authority against Flynn Pharma Limited and another, and also against Pfizer Incorporated and another.
Lady Rose, with whom the other members of the court agree, is handing down the judgment in this appeal.
The question as to whether and when regulatory bodies should be ordered to pay the legal costs of someone who wins an appeal challenging a decision taken by that body is an important one. A lot of public money can be spent on the costs awards that courts and tribunals make. It is also a difficult question. On the one hand, there is a concern that if costs orders against a regulator are imposed too readily, even when a regulator has acted reasonably, there may be a chilling effect. That is to say, there is a risk that the regulator will hold back from taking action against an individual or company, even if it considers that it would be in the public interest to do so, because it is worried that it will face a large cost spill if the individual or company challenges its decision in the court and the court rules against it. On the other hand, parties having to bear their own legal costs, even when decisions taken against them are determined to be unfounded or fines imposed are held to be excessive, raises issues of fairness. This appeal concerns the Competition and Market Authority, which I will call the CMA. Although the CMA performs a range of regulatory functions, in the present case we are concerned with its role in investigating companies suspected of breaching competition law and finding those found to have done so. In the present case, the CMA invested both appellants, Flynn Pharma and Pfizer, for competition law breaches in respect of the supply of prescription epilepsy drugs. Flynn Pharma was fined over £5 million and Pfizer over £84 million. The two companies appealed the CMA's decisions to the Competition Appeal Tribunal, which I will call the CAT. The CAT allowed the appeals in part and remitted the case back to the CMA for consideration. The appeals before the Supreme Court concern the costs awards made by the CAT after it allowed that appeal. Reflecting the fact that the two companies had been successful in part, the CAT ordered that the CMA pay a proportion of their costs of bringing the appeal. The CAT did this under its powers conferred by Rule 104, Sub-Rule 2 of the Competition Appeal Tribunal Rules 2015. This rule states that the CAT may, quote, make any order it thinks fit in relation to the payment of costs. The rule goes on to list a number of factors that the CAT may take into account, but it does not lay down any particular starting point or presumption as to what costs order should be made. By making the order it did, the CMA was following what had long been the CAT was following what had long been the CAT's practice in appeals concerning alleged competition law infringements. When exercising its discretion under Rule 104, the CAT adopts as its starting point a position that costs follow the event, meaning that the unsuccessful party should pay the legal costs of the successful party. As in the present case, where a party was successful only in part of its appeal, that could be reflected in an award of only a proportion of its legal costs being paid by the other side. The CMA appealed the CAT's cost ruling to the Court of Appeal, and the Court of Appeal set aside the CAT's costs order and replaced it with no order as to costs. This meant that each side had to pay its own legal costs for the appeal before the CAT, notwithstanding that the companies had been successful in part in challenging the CMA's decision. The Court of Appeal's reasoning for doing so provides the central legal issue in this appeal. The Court of Appeal looked at a line of cases beginning with a case from 2000 called Bradford Metropolitan District Council against Booth. In that case, the court had held that it was not appropriate to impose a costs order on an unsuccessful public authority where it was deemed to have been acting reasonably in the exercise of its public duty, even though its decision was ultimately held to have been wrong. The Court of Appeal in our case considered that the effect of this, as interpreted in later cases, was that the CAT's starting point of costs follow the event was incorrect. Instead, the Court of Appeal concluded that the right starting point for costs awards in the CAT in cases like the present is that no order for costs should be made against a regulator who has brought or defended proceedings acting purely in its regulatory capacity, unless the regulator has acted unreasonably in some way, and that was not alleged to have been the case here. Flynn, Pharma and Pfizer now appeal to the Supreme Court, contending that the Court of Appeal was wrong to conclude that that was the correct starting point, and this is the main question in the appeal. The Supreme Court now unanimously allows the appeals. In the Supreme Court's view, there is no generally applicable principle that all public bodies should enjoy a protected costs position when they lose a case which they have brought or defended, even when they are doing so in the exercise of their public functions in the public interest. The principle to be derived from the Booth line of cases is rather that when deciding what costs order to make, an important factor that a court or tribunal should take into account is the risk that there will be a chilling effect on the conduct of the public body if cost orders are routinely made against it. In some circumstances, the potential chilling effect on a public body will indicate that no order as to costs is the appropriate starting point. But where the Court of Appeal went wrong, however, was in jumping from that conclusion to saying that there is a wider principle that in every situation and for every public body, it must be assumed that there might be such a chilling effect, and therefore that the public body must be shielded from costs or awards being made against it. The Supreme Court considers that whether there is a real risk of such a chilling effect depends on the facts and circumstances of the public body in question and the nature of the decision which it is defending. It cannot be assumed to exist. As to who decides whether such a chilling effect is sufficiently plausible, in the Supreme Court's view, this is an assessment best made by the court or tribunal in question. In this case, that was the CAT. The Supreme Court concludes that the CAT did not err in deciding that costs follow the event was the correct starting point for this kind of appeal. It is observed that this practice was well established by 2015, when the procedural rules which give the CAT a broad discretion as to costs was reviewed and retained. If the Secretary of State had been unhappy with how the CAT was exercising its power, the rules could have been changed then. Further, the way that the CMA's functions are funded by the government dispels any concern that its conduct might be influenced by the risk of adverse costs orders. Before accounting to the Treasury for any income received from the fines it imposes, the CMA can deduct the value of any legal costs it has to pay to the winning side in other cases. As a result, it's very unlikely that there will be any adverse effect on the CMA's finances arising from a liability to pay the costs of a successful appellant, provided that it collects fines from other infringement decisions during the course of the year. There are also, in the Supreme Court's view, good policy reasons to adopt a starting point of costs following the event. It is right that the CMA is subjected to the discipline associated with having to pay a successful appellant's costs if ultimately the CAT concludes that the CMA's actions were not well-founded or that the fines it imposed were excessive. The Supreme Court also notes that the CAT has shown that it is well aware that a starting point is only a starting point. A survey of the CAT's decisions reveals a range of ways in which the CAT can and does take account of the nature of the body appearing before it. This demonstrates that the CAT has developed a sophisticated approach to costs awards, balancing the many competing factors pulling in different directions to reflect this. The Supreme Court therefore allows the appeals and reinstates the CAT's costs ruling.
The court will now rise. Thank you.